Welcome, everybody. Planet Green Trees, episode 159. We are calling it Blue Water, and we will explain why and why we've given it that title. But tonight, of course, is August 1st, 2013, and you're listening to Planet Green Trees. The call number is 1-347-326-9626. I'm your host. Good evening. My name is Michael Comorn from Comorn Law. Side me to help you bring Michigan's cannabis community the most entertaining and timely information. We've got Chad from the Birmingham Compassion Club.
And syntactically correct information.
There you go.
As well.
Low risk. Jimmy Lowe of the Third Coast Compassion Center.
Hello.
Officially the producer of the show, bringing together the timely guests as we are going to be explaining tonight. When news happens, we get the guests involved on the show. So, Jimmy, thanks for all your hard work. Also, absent for the last couple of weeks. I know he was sick last week, but we're glad to have him back. Rick Thompson of the Compassion Chronicles, the editor-in-chief. Welcome, Rick. Welcome back.
Hey, everybody.
Rick, of course, will be bringing us the most recent and up-to-date news. Also in the studio, our good friend and one of my, what I'm calling my family members now, Dewey, returning, and we want to give a big shout-out to his better half, Pam. Hope you guys are good. Dewey, welcome.
Hello, everyone.
So tonight's show, we're going to be talking about the Blue Water Compassion Center and the dismissal that took place. We're going to be having attorney Paul Talinda, who was one of the defense lawyers on the case, who will be joining us, along with defendants and founders of the club, the Blue Water Compassion Club, Jim and Deb Amsdell. Also, we want to highlight, of course, all the successes that are happening throughout the community, and it's amazing the way it works week to week. Last week we were discussing the unfortunate developments in the Court of Appeals in the edibles case, and the week before the Section 4 ruling regarding People versus Jones. But this week we're celebrating, of course, the dismissal of the Blue Water Compassion Center, and also successes in Ferndale and Jackson and local cannabis decriminalization ballot initiatives, where the signatures were turned in and the ballots were created and will be at the next election. So we're also going to be in touch with the dispensary rate in the upcoming medical marijuana policy change, Ypsilanti, and we're going to take a moment to celebrate more good news that Illinois is now the nation's 20th medical marijuana state. Our superstar guests are going to be calling in. Going to be Tim Beck, a frequent caller and admitted listener to the show. Of course, those that everyone knows Tim Beck. He's the godfather of the marijuana and medical marijuana movement in Michigan, and we're honored to have him calling in and giving his thoughts on the political developments there, as well as one of the soldiers out there, Steve Sharp. I know had a tremendous amount of equity sweat, we could say, in organizing and bringing people together and getting the signatures necessary in Jackson.
That's right.
So they're going to be calling to discuss the gathering efforts in Jackson, Ferndale, and updates of the situation in Lansing. As I said, Paul Talinda, a good friend, outstanding lawyer, is going to be discussing the case that was dismissed in the St. Clair County Circuit Court. And also calling in friend Steve Green from the Michigan chapter of the Human Solutions. I want to thank all of our contributors to tonight's show, the producer Jamie, Rick Thompson of the Compassion Chronicles. Also want to give a shout out to our sponsors, the Michigan Medical Marijuana Association, michiganmedicalmarijuana.org. Please visit the website, participate in the forums. A big thank you to the administrators and moderators who participate and volunteer their time to try to make that forum a safe, comfortable environment for the medical cannabis community to evolve the conversation. Comorn Law, 1-800-656-3557. I want to give a shout-out to our friend Kevin Spitler, MedJoint Community Compassion Center, and the Ohio endeavor. Maybe we're going to hear from him one of these days about the Ohio developments. And, of course, I want to give a shout-out to our friends at the Marijuana Ranch and Cultural Center. Call for tours and other information on culture of cannabis, 313-422-5281. So we've got a packed house of outstanding guests, as well as great topics to talk about. I would say last week we did celebrate a dismissal in a Comorn law case. The prosecutor folded. We were calling it the victory in Paw Paw. But I want to talk about, for tonight's rant, I'm going to discuss and kind of lay out a little bit of this circumstance that finds itself as such a, call it like a diamond in the rough of what's been happening in some of the litigation regarding dispensaries or any kind of transfers that are taking place at an organized location or being a resource center where patients can get their medicine other than directly from their specifically identified caregiver that they're connected to through their registry program. This has been an ongoing issue, of course, in Michigan. The debate is there dispensaries, are there not dispensaries, are they allowed, are they not allowed, and what does it mean? And, when I get in the discussion or legal debate about it, it's really not an outline of dispensaries per se. That is a thing. Dispensaries are not mentioned in the Michigan Medical Marijuana Act. There's much debate as to in terms of whether the voters intended it when they polled the 63% voted for the Michigan Medical Marijuana Act. And I think it's kind of been resolved as to whether or not the writers of the initiative intended to have dispensaries. But that was at a different time, and there's different strategies that supported why that was the position. But as we've traversed through the Michigan Medical Marijuana Act, from my own experiences representing people that have been charged with crimes involving what would be called dispensaries, again, it's not a crime. It's not like you're charging the dispensary the crime. The crimes that are being charged are the individuals who are involved with the selling or transferring of marijuana. So when they say that there's outline of dispensaries, it's kind of it's not really a thing. It's really that they're charging and alleging criminal activity by the people that are working at this location. Call it whatever you want. But as we've gone through the act, there's been numbers. Obviously there's been a lot of dispensary cases. I think the first ones we've defined as being the end of the Renaissance era, and it commenced into the Dark Ages. We would say in 2010. The history of the Michigan Medical Marijuana Act. It was instigated by the Oakland County Prosecutor's Office and self-described by them as a crusade against medical marijuana, just appropriately for the Middle Ages of the Act. Anyways, as the various cases had developed and strategies had been formed amongst the attorneys, and the two cases, one in Ferndale and one in Waterford, were litigated, and there was a theory that had been offered which was successful in the Ferndale case. That one was not successful in the Waterford case. And the success of the Ferndale case, of course, is being appealed. I don't know that there's a result. I think we're still waiting on something. But the theory that was forward, and it is relevant to the discussion that I'm going to get into, and then we're going to talk about Paul Talinda and the Amstels, is this idea of just general concepts of due process. General ideas of a notice of what is a crime and what is not a crime. Some of the testimony that was taken in some of these cases that I referred to involved people saying things like, well, there was no specific position at this time and we thought that they were legal. Or, the Oakland County Prosecutor's chief executive officer of the Oakland County, Brooks Patterson, had supplied information to the community and the community leaders in the various townships and cities of different choices that they could have in terms of, quote-unquote, dealing with dispensaries. That doesn't sound like their outline was the testimony. And there wasn't a specific posture taken or notice given that if you do this, you're going to get charged with a crime. Nothing, silence. So some of the arguments that were forward in one of the cases was that was the circumstance. How would they know? And where does it say? We can argue and debate it, but to suggest that it's going to be determined by that case, that those activities are not predetermined to be clearly defined as legal or illegal, and we are going to make an example of that case. Well, these are the arguments that were made, and that's what happened. That's the way many of these cases were ruled upon. I can vividly recall, I was going to pull it out and read it, but one of the opinions that was authored by one of the Oakland County judges as we presented this evidence of there not being any notification of due process was that amongst other things, that ignorance of the law is no excuse. In other words, you should have known better. There's no law, but you can't cry that we didn't know, because you should have known. And to me, that was one of the most ridiculous arguments, just from the general principles of due process, of having clear notice of what is a crime, and with unequivocally being able to define exactly what that behavior is going to be that police can arrest an individual for. Otherwise, it's a guessing game, and the criminal justice system was not intended to be that. Nevertheless, I would just also point out that the opinion, ironically, was reliant upon exclusively federal law, because many times patients, caregivers found themselves in federal court arguing that, well, we didn't know that state law defenses didn't apply in federal court, and the federal court judges would say, ignorance of the law is no excuse. But they don't have a medical marijuana defense in federal court, and it wouldn't apply anyway. So to be able to argue that is to argue ignorance. However, but to argue that the specific notice of what is a crime and what is not a crime is a state law determination, and it should not be decided by the trial courts, meaning it should either have been determined by the Court of Appeals before, so there's a clear message, or otherwise we are infringing on basic principles of due process. So I say all that as a precursor to what is a really enjoyable opinion to read, authored by the Honorable Cynthia A. Lane of the 31st Circuit Court for the County of St. Clair. And as I said, we're going to have Paul Tolinda give us some of the background of this. But essentially, for those that don't know, there was call it a dispensary. The Amstels, Deborah and Doug, James, Amanda, a few other individuals that worked there were charged on the premises involved with activity related to the Blue Water Compassion Center in Kimball Township. And the Attorney General's office is the party prosecuting, meaning that it was not a local raid. It was not necessarily the local township police, or maybe even sheriff's department, but instead may have been just exclusively the Michigan State Police, directed by the law enforcement chief of our state, the Attorney General. There's several charges. One, criminal enterprise, which I know is a 20-year felony. Conspiracy to deliver, again, 20-year felonies. Anyways, the court goes on to describe some of the facts of what takes place. It does reference that defense counsel for the defendants filed a motion to dismiss claiming insufficient evidence, insufficient notice, and ex post facto prosecution, arguing that at the time of the alleged unlawful conduct, caregiver to patient transfers of marijuana for a price were protected by the plain language of 333.26424E. And then on February 8th, 2013, the court goes on to talk about the McQueen decision, which had held that individuals who sell, transfer, deliver marijuana to another person without being connected to the state registry are not entitled to immunity set forth in the subsections. So the various positions that were argued are as follows. The defendants argued that because McQueen's interpretation of the MMA made the sale of marijuana between a caregiver and an unconnected patient unprotected activity for the first time, it should not be applied retroactively. Applying McQueen's interpretation of the act retroactively makes what was previously legal conduct illegal. Such retroactive application operates as an ex post facto law in violation of the defendant's right to due process. In support of their argument, defendants rely upon several cases, blah, blah, blah. The Attorney General responds that ignorance or mistake of law is not a defense. Where do they get that from? In response to the defense ex post facto argument, the Attorney General argues that the defendants have not met the elements necessary to sustain the burden because they are being prosecuted under the Public Health Code, not the MMA. Since the Public Health Code is very clear in its prohibition against the delivery of marijuana, it has been in place for decades. Defendants' assertion that they did not have notice of the illegality of their action must fail. The court goes on in its opinion, and I don't want to read the whole thing. I want Paul to maybe make some comments on some of his favorite parts as well. But the court talks about this, and I think it's important to reiterate it as one of the things that we highlight. But I would say this, that this issue has come up in other cases. I even mentioned last week when we were talking about the Victory and Pawpaw that in the bind-over, when the district court had ruled after hearing the testimony to preliminary exam, and I'd argued that, in fact, there was immunity, that the court needs to make a ruling, and consistent with Jones, even if I disagree with that case, the court needs to make a ruling on whether or not immunity applies based on these facts. It's not just at a preliminary exam whether or not probable cause exists that a crime has been committed, probable cause that the defendant's committed the crime. Instead, it's in addition to that, does immunity apply? And has there been, has the presumption of a compliance been overcome by behavior that's not for medical purposes? But anyways, what happened in that bind-over by the judge was that he utilized the language of the April 2013 amendments to what has been described from the definition or changing the amendments of an enclosed locked facility for outdoor grows. And he specifically utilized that language in saying that the behavior of my clients as he heard the testimony at the exam did not conform to that, a law that had been implemented, written, described, and put into effect in April of 2013 when the alleged culpable date was in August of 2012. Same arguments being made here, but that, of course, was an argument based upon legislation. But this issue has been before the community many, many times because it's the Court of Appeals opinions or the Supreme Court opinions that have the direct effect on how the law is going to be interpreted. And if the opinion comes at a time later on, then the behavior that's being judged as to whether or not it's a crime, how can you one say that it's fair? Well, the Attorney General, and as I talked about in Oakland County and other places, ignorance of the law is no excuse, and the law, it's always been illegal under the Public Health Code. Nonetheless, the court goes on to say, with that said, it is well recognized that ex post facto clause of the United States Constitution does not apply directly to the judiciary. However, the principles apply to the judiciary by analogy through the due process clauses of the Fifth and 14th Amendment. Therefore, retroactive application of a judicial decision violates due process when it acts as an ex post facto law. An ex post facto law has been defined by the United States Supreme Court as one that makes an action done before the passing of the law and which was innocent when done criminal, and punishes such action or that aggravates a crime or make it greater than it was when committed. So as a general rule, judicial decisions are not to be given complete retroactive effect, which is what I was talking about. Clearly, not supposed to be complete retroactive effect. However, if a judicial decision is unexpected and indefensible in light of the law existing at the time of the conduct, retroactive application of such a decision is problematic. And I'm sure that Paul will discuss this as probably one of the inherent arguments that the court obviously took interest in, heard from both sides in terms of, is this an unexpected decision? And would it have been indefensible in light of the law existing at the time of the conduct? The retroactive application of an unforeseeable interpretation of a criminal statute if detrimental to the defendant, generally violates the due process clause. Here, the critical question is whether defendants at the time that committed the alleged acts in 2011 were placed on notice that those actions were illegal and would be subject to criminal prosecution. In the judgment of this court, they were not. Although the MMA does not impose criminal sanctions, failure to meet its requirements may and likely will result in the filing of criminal charges against non-compliant persons. Because of this reasoning set forth, it applies here. So having reviewed the MMA, the court concludes that a person of ordinary intelligence would not have concluded prior to McQueen that the MMA required a registered qualifying patient and a registered primary caregiver, as they were referenced in the statute, to be connected to the state's registry process in order for a caregiver to assist the patient and receive compensation. A person of ordinary intelligence could reasonably assume that the legislature intended the registry requirement of 33326.424B to apply to subsection E. This would have been stated more clearly than it was. Therefore, the court concludes that there's no way that the defendants could have been put on notice, and to charge them with crimes without the proper notice is patently unfair, and court found that it was necessary, therefore, to dismiss the charges. it's fair to say that the Attorney General will appeal the case. And one of the things that I want to talk about when Paul gets on the line is whether or not there was an issue or arguments that had been made that there needed to be a premise that the behavior of transferring from any caregiver, any patient, was considered lawful at the time. And were they applying the Chamberlain opinion from McQueen, from the Circuit Court? Was that addressed? Was the Court of Appeals opinion, which broke down the various types of transfers in a much different way, bringing the fact that money was transferred one way or the other as one of the determinative factors of immunity?
Completely different than the Supreme Court's logic.
Completely different. So really, or what I'm going to guess, we'll have to hear from Paul, did they say, look, you got a trial court opinion that says it's totally good, you got a Court of Appeal opinion that says something completely different, and a completely different interpretation of the law with a dissenting opinion that justifies it all? How could anyone in their right mind be given fair notice in terms of due process of what a crime is? Anyways, that's the rant. I think it's going to be a good show, and it's very exciting days here for the medical cannabis community. At least we should wallow in it when we can, and we'll probably watch the thing ride along the way up the Court of Appeals. But you listen to Planet Green Trees. This is officially episode 159. We're calling it Blue Water. We're going to be hearing all about it tonight. Call in 1-347-326-9626, and we'll be right back.